We are live.
We are live. This is Senate Judiciary. We're taking up S15, a bill dealing with presumptive probation, and it is part of the Justice Reinvestment 2 effort. And one of the suggestions from the Justice Center, the Council of State Governments Justice Center, who work closely with Ben Nogowski, our legislative counsel, in drafting the bill. And with that, ask Ben to walk through the bill, and then we have some testimony scheduled.
Okay, so I just passed around just a reference sheet for the committee. It's just 13 VSA 30 15 sub 7, which is just the listed crimes that it will be mentioned in this. So do you have any more?
I was gonna say, I don't have that.
Oh, I guess
got-
that's a Senator Sears.
I think I got some extras.
Okay. So just a point of reference for the committee to have, so
Who needs extra?
you're aware of the, what it was. 31 sub 7. Citation. For the record, I'm Ben Obrowski from the Office of Legislative Counsel. Before the committee today is S15, an act relating to establishing presumptive probation for non-violent crimes. What this bill does is that it establishes presumptive probation for nonviolent felonies and misdemeanors for first-time offenders. The bill permits prosecutors to file a motion and present evidence to rebut the presumption and argue for an alternative sentence pursuant to 13 VSA 7030. The defendant would be able to present evidence of response supporting presumptive probation, and the court hearing the motion must consider certain factors in making the determination. And then once the court makes an order, it could be directly appealed to the Supreme Court, and the order would not be stayed unless a showing was made. There was a likelihood to prevail on appeal. So to get into the details of the bill, starting on section 1, again, throughout you will see sort of modernizing language, but what this does is that in the maximum and minimum terms, this in 7031 sub D, there's a reference to 0 minimum sentence, but it also adds presumptive probation pursuant to 205A to be for a nonviolent misdemeanor or felony to report probation parole as directed by the court. You scroll down into section 2. These are amendments to 13 VSA section 7554. Again, updating language to be more gender neutral. You'll see that again on the next page on line 10. We're also seeing changes to the cross references of 28 VSA 201 to now 301. That is changing the location of the definitions of nonviolent felony and misdemeanors into really a more logical place within the statute. So those are also changes you'll see throughout the bill. Again, at the bottom of the page, another gender neutral update, cross-reference update on the top of page 4. And so this is what I just referenced. Section 3 is the amendments to section 201 of Title 28. Changing the location of those definitions of nonviolent felony and misdemeanor. So a nonviolent felony is an offense that is not a listed crime as defined in 13 VSA 5301 sub 7, which I passed out to you, or an offense involving sexual exploitation of children in violation of 13 VSA chapter 64. Nonviolent misdemeanor includes the same thing, but also adds 13 VSA 1030 in reference to the exploitation of children.
Ben, can I interrupt you real quick? Do we also have a definition of what a first-time offender is and what that covers?
There is no definition in the bill.
Okay. Should we have a definition of that? Because I mean, I know on the surface we know what it is, but I mean, is it counting somebody who has a conviction from out of state, or is it just state offenses? I mean,
that's a good question, and that could be, honestly, a policy decision as far as making that definition to exclude only first-time offenders committing crimes within the state of Vermont. It could also include out-of-state offenders, I mean, I think the plain reading of it right now, it would be more inclusive than just those in Vermont.
This is clear, this is a legal question, so actually it is for you this time. Would first-time offender not include someone with a sealed record of a previous offense? Or
That's something that I would have to look into.
Okay.
But yes, I can get you that. That's that. And also my colleagues at other states attorneys or Attorney General may be able to answer that as well. And again, so continuing on with the bill, probation is also defined in this section. This is not changed substantively, it's just the listing format. Moving on to section 4, which is 28 VSA 205, which discusses probation, and this is really the heart of the bill, which establishes the rebuttable presumption of probation for those crimes. So really probation right now, what it is that there is a sentence that's passed, but it's suspended, and it can be all or in part, so that the person is placed in the care of custody of the Department of Corrections, and then they can implement certain conditions in their release into the community, but there is a public protection factor, if you will.
Question for you. So would this cover contested sentence hearings, plea bargains, or both of those? Would it cover everything?
So the way that the language reads is that it'd be first-time offenders adjudicated guilty. So that could be through plea agreement, that could be through going to trial, contested cases. So it was written in a way that it would cover those scenarios.
Okay, thank you.
So again, the presumption is that for these crimes, these people go to probation. However, there is a rebuttable presumption that the sentence is suspended unless the person can voluntarily waive it, because as has been discussed on other bills, someone can just not want to engage in the process of entering probation, and so they can waive this presumption to enter it. But that is something that the defendant would be able to decide. And that is in subdivision 1 of this section. Subdivision 2 is amended now to, and you'll see the strike through language here, which in subdivision 2 and 3, it talks about the term of probation for misdemeanors and felonies. For misdemeanors, shall be for a specific term not to exceed 2 years unless the court basically changes its mind based on the interest of justice. For felonies, it's a term not to exceed 4 years. This is struck in this section, but it's just moved down to later in the statute to make room for these provisions. So what subdivision 2 is replaced with is basically procedure to rebut that presumption of probation. So the state may file a motion and present evidence requesting an alternative sentence to presumptive probation is appropriate. They would have the burden of proof to rebut the presumption by a preponderance of the evidence, so just meaning more likely than not. And then the defendant would have the right to respond to the motion filed pursuant to the subdivision and present evidence in support of presumptive probation.
Sorry. So, and when that evidence is presented, is that it's viewed in the light most favorable to the state in that circumstance?
It's not outlined in the statute, actually. And I believe when it comes to probation, it may be, but I'd have to do research on that as well. So basically, it gives the defendant a similar right to present evidence on their behalf in arguing in favor of the presumption. The court may hold the hearing at its discretion, and considering an alternative sentence, whether it's appropriate or not, there are certain factors that are non-exclusive, but that must be considered in the determination. One is whether the offense was committed with the use of a dangerous weapon, whether the person used threats or coercion in the commission of the offense, and then the age and vulnerability of the victim, whether the person was in a position of responsibility or trust over the victim, or whether the individual abused a public position of responsibility or trust. And again, you'll see here in subdivision 3, this is the portion concerning nonviolent felonies and the term of probation that was just moved down. This is now replaced with the procedure if the state were to meet its burden, that an alternative sentence should be ordered. So the court would issue a written order specifying the appropriate alternative sentence pursuant to 13 VSA 7030. So what that statute reads is that it can be a sentence of incarceration, it can be a deferred sentence, it can be furlough, it could also be a reparative board, but this specifically outlines that a reparative board on its own would not be a sufficient alternative sentence to presumptive probation. That again is really to hedge against any potential safety concerns. A reparative board may not be considered really sufficient enough to replace probation, which would have certain conditions attached to it. And then again, as you can see here, subdivision B, this is moving that definition of nonviolent felonies, and it's now replaced with the provision that a decision of the Superior Court is appealable as a matter of right to the Supreme Court. So it's not the Supreme Court. There's permission is not needed in this. It's as of right. And then the court's order shall not be stayed pending appeal unless the person is subject to probation is reasonably likely to prevail on the appeal. And the way that would be done is that there would be a motion to stay, or within it that would outline one of the reasons that there's a likelihood of prevailing on the appeal. So it's really just further motion practice before the court. And then again, subdivision 4 is moving, and 5 is moving those terms of probation for misdemeanors and felonies down lower on the list. Substantively, they are not changed. Again, section 6, section 7, those are all currently in the statute. They are just amended to add to the list as I explained before. And then finally, in section 4, summons or arrest of the probationer. This is where those definitions of nonviolent felony and misdemeanor currently reside. So they're being struck and just moved to the previous section. And then the effective date of this is that it would go into effect in July 1st of this year.
Any questions? Ben, thanks very much. Very thorough. Our first witness is Matt Valerio. Back again.
Do you mind if I wait to hear what the Department of Corrections thinks about this?
I have no problem with waiting. to hear.
Because
Whatever I do, Matt just likes to follow. So it only works like that, right?
my initial thoughts on the bill will probably be supplemented by what they say. And I think I'd rather wait.
Well, I have no problem with hearing what the Department of Corrections has to say.
Would you like me to come up?
Are you ready?
Sure,
Commissioner?
sure. This, I think, will be less contentious than my last this morning. Morning, everybody. Nice to see you all on back-to-back days. My name is Nick Dimmel. I'm the Commissioner of the Vermont Department of Corrections. And I have Dale Crook with me, who's our Director of Field Services, so he's managing our probation.
Welcome back, Dale.
Staff as well. So I apologize, I missed the reading from Legislative Council, but I have a copy of the bill. You know, I have a couple of kind of overarching comments. I will say, you know, from the department's perspective, we will implement whatever probation structure is in place in the state. I think we really strive to go out of our way to execute that as well as we can. And Dale's team does a great job with that. But we're really the receiver of bills like this. You know, you provide the rules and then we simply execute it. You know, it struck me in reading this legislation that through justice reinvestment, we spent a lot of time looking at the correction system, the community supervision system in the state of Vermont. We made some changes, many of which were deeply evidence-based, were thought through for long periods of time to try to draw down the number of individuals who are incarcerated in the state of Vermont. We showed you some of that data yesterday, and I think, you know, by and large, at this stage, we've shown that that initiative and the implementation in Vermont has been very effective. We've really drawn down the incarcerated population. The populations that remain in our system tend to be violent charges, convictions for violent crimes, folks who just repeatedly are non-compliant with their community supervision to an extreme level. And folks who have very high risk scores. And we can talk about kind of the risk assessment tool. What we don't have are, the historical non-violent kind of first-time offenders. Those folks generally do not exist in the incarcerated setting anymore. I think also we've seen market success in diversion programs across the state, where the data would support that if you are a nonviolent or a first-time offender and you go into a diversion program, those tend to be very successful at preventing people from recidivating to reoffend in some crime. And so I'm cautious with legislation like this in so much as we did a whole body of work through justice reinvestment that is only now starting to take root, and tinkering with the system that we just worked on gives me some pause. I also think the population that is described in the bill is largely being served fairly well right now. Diversion programs, as I mentioned, seem to be working well. We're not incarcerating first-time nonviolent offenders. We're not largely incarcerating misdemeanor convictions, and we can show you some of that data. And so, I guess I would ask the committee what the ultimate goal of the legislation is, and if there isn't a better way to achieve some of those outcomes.
Commissioner, can I ask, sorry, can I ask a question about something that you had mentioned just a minute ago regarding conflicts or potential issues with justice reinvestment and what some of those issues might be that you might foresee?
Well, I mean more that we kind of restructured community supervision in the state. We worked on trying to draw folks out of the system. And if we continue to then tinker with that, I'm afraid that there are occasions where we might begin to run afoul of the ultimate intent of the changes we made through justice reinvestment. I think on specific program justice reinvestment initiatives, Dale could probably speak more intelligently than I can, having been the implementer of many of those programs. But that's my concern is we went through a years-long process to kind of refit our correction system. And then COVID occurred, and so we've had some lag there, but we're seeing the fruits of that labor. And now we're talking about tinkering again on the fringes of the probation side.
And Senator Phillips.
Yeah, I guess I'm a little confused if we're largely already not incarcerating the people that would be impacted by this bill. What impact would it have? Like, I guess I'm just a little confused how this would be harmful if we're already not incarcerating these people.
Sure, that's a fair question. I'm not sure that it would. I think that's a legitimate question. I think one of the concerns, in my own opinion, in reading this legislation is, right now, many of the folks that are described in this bill would go into a diversion program. But if this presumptive probation were established, and folks, instead of going to diversion, were put on presumptive probation, they would then have the criminal record that otherwise through diversion is avoided. And so, in fact, some people could end up with a criminal record who otherwise wouldn't have, which I think is harmful, and then runs kind of counter to, I think, the ultimate aims of what we're trying to do here.
So as a quick follow-up to that, one of the conversations that came up in our earlier testimony on a different bill was adding presumptive diversion to this bill for a list of things. Would that help ease some of your concern?
Potentially, I'm not sure what that would look like. I think
I'm more sure of what it would look like.
in some ways we have presumptive diversion. I know some of that is up to the.
Well, there's geographic issues with all of this.
Mm-hmm.
So if I'm in Bennington, something might happen.
Sure.
Versus if I'm in Chittenden County, let's say it's shoplifting. sizable,
Right,
over $50.
would that be dealt with
How's
differently?
it gonna get dealt with in Bennington versus Burlington?
Yeah,
Well, and I think my other inequity piece here is we know from the data, and I'm sure as the Bureau of Racial Justice Statistics continues to give us data, that we're gonna see more and more, there is bias in sentencing. And by universalizing this process, one of the problems it seeks to solve is that bias in sentencing.
yeah, that's an interesting perspective. I think in general, that's true. There are certainly biases.
You have a bill on that too?
Excellent.
So without seeing what a presumptive diversion program would look like, I can't comment too deeply, but I think that's an interesting concept. I know, and I'm not sure that the state's attorney's had an opportunity to testify yet. I know there's some current concerns about what charges would actually be included in the language here. And I think, we would share some of those concerns, and we certainly want to see what are the charges that would fit within a presumptive either diversion or probation system. There is one piece of the bill that I'm a bit concerned about, just as a impact on the correction structure, and that's on page 8, where we talk about probation officer responsibilities to do some reporting and make petitions with the court. I think the process that exists right now would already solve for the intent of this section, this paragraph of the bill. But if we included this, it would create kind of another structure on top. And so if the bill were to go forward, certainly this is something that I hope we can work with you on, just to make sure that we're not creating redundant processes or contradictory processes or putting additional onus on probation staff to do reporting with the court. And certainly I think Dale can speak to this if we have some more questions about how this could impact your kind of line probation officer running a case.
I think that's existing law.
So I think this is pulled from I don't think this is the process, let me put it differently. I don't think this is the process that's currently followed on matters like this. But it's certainly something I think we can work with legislative council on and make recommendations if you're open to them on what the impact would be for
Yeah,
probation.
open to whatever, but I think it's existing law.
Dale, do you have any context, Dave?
The mechanism we use right now is the file violation within the expiration of the term. And that's not necessarily to have them report to jail, but is to have it brought back before the court. That's the process that's occurring now that would address this. Before the end of the term, if someone has not completed their conditions of supervision, it goes back before the court, and the court decides the resolution of that violation.
Other? I think it's, I appreciate the comments. Let's try to work together to make it work.
And I'd be interested to hear how that moves the Defender General one way or the other. But certainly, we're always willing to work on trying to make the bills as best they can be.
Maybe the state's attorneys have suggestions too.
Certainly, and I think you'll hear, without previewing too much of what Tim's going to say, I think you'll hear some testimony about the charge types, and we may need to add specificity about what charges will be considered nonviolent, because I think there are some charges that fall outside of your normal kind of Big 12 type categories.
Well, the listed crimes, we've got so many lists, it's sometimes hard to keep track of.
Sure. But certainly
Adding to listed crimes.
that would be a concern if there's crimes that are considered nonviolent, but really do have kind of a violence element. We want to make sure those.
We want to get somebody next week or the week after from the Justice Center to speak to us about the bill. They were actively involved in the drafting of the bill, working on it, and had reasons why they thought it was a good idea as part of justice reinvestment. It's one more tool in keeping people hopefully out of your system. Out of the incarceration setting.
We're certainly fond of that part of you know, we want to keep the population down as low and really get it limited to the individuals who have the really high risk scores who are there for violent offenses. I think we're all in agreement that in general, that's the body of policy we want in place. But I'd be happy to answer any other questions as they come up, and certainly welcome to stay for the hearing. Thanks, Matt.
Matt, you want to go next, or do you want Tim to go?
Well, I'm both sure.
I'm happy to go, unless, I didn't know if Judge Zone had scheduling issues or whatever, I'll have to defer.
Oh, yes, I'm sorry, Judge.
I have no scheduling issues. I'm happy to back cleanup. Let everyone else go. I'm good.
Are you in Bennington?
No, actually, I'm still waiting to that determination. With the weather, I'm thinking I may be doing that remotely. We've added a hybrid option so that people could make it from around. And so I may not be heading down. We'll make that decision in a few minutes when I see the latest
Drive
reports.
carefully. It's supposed to start at about 4 o'clock in Bennington.
I think you may see me appear remotely in Bennington. I may not make the trip down in person with that.
Thank you, Mr. Chair. Sim Leaders Dumont, attorney with the Department of State's Attorneys and Sheriffs, and I deeply appreciated reading this bill and the intentions behind it, and also listening to the commissioner about some of the on-the-ground work that DOC has done. And I think in terms of setting the stage for what I'll talk about, sometimes there can be a presumption that the state's attorneys want to come in and it's status quo. What I want to do is more talk about practically what we've seen on the ground and how this might interact with that, as opposed to issue spotting for the sake of issue spotting. So in terms of the context, as stated, we do really appreciate the intent of the bill to, quote, the bill help create greater racial equity in sentencing. And I'll echo from the field what the commissioner said, that there are some big picture potential concerns about overbreadth, the listed crimes. So I'll talk about briefly, and I have a very fun handout, which I'm happy to talk about later, but I don't want to distract, about potential crimes, very large, about 50, that are violent in nature or might not be swept up in this and would be presumed probationary, despite the nature of those crimes. So in the context of sentencing, when we have made sentencing arguments, we often look to case law and statute, but in State v. Hughes, we're supposed to take a individualized sentencing process approach to examine each person that comes before the court. And so that can, people's lives are fluid. And so you might someone might come in with a charge, and by the time sentencing rolls around as a prosecutor, you might have really changed your thinking on how that person might be rehabilitated, how the victims are feeling about the case, because as we know, cases take a long time to go through the system. So a presumption at the front end might feel different on the back end. And that individualized approach that judges then make when they're hearing arguments, and ultimately it being their discretion, is something that is in our case law, and I think is helpful in terms of looking at each person separately. And looking across the country, I've seen, and I haven't done the deep research across the country, but Kentucky, Oregon, Colorado, and South Dakota have all done some version of this. And the idea of this being a default type of a sentence or consequence, but also with some rehabilitation, is about low-level drug offenses. This bill doesn't mention low-level drug offenses specifically, but I presume if it's in that category, that might be some of the intention behind it. So in Vermont, we have moved towards community-based sanctions for these first, and when I say first time, I do mean the layman term, I think that we're all working with, but I know there's questions about what that might mean. But community-based sanctions, diversion, we often make possession of drug cases that are first-time folks. Diversion, Tamarack, there's often mental health and substance use concerns that are overlapping, which the Tamarack program really addresses well. And if they're successful, they don't have to have that docket number. The case gets dismissed and they get to enjoy eventual expungement of those cases, and it's off the record. But also CJC referrals can happen pre-charge, post-charge, right before you have your trial. And that's always a great option as well if someone's needs can be met truly fully outside the system. And then treatment court. We have it in different parts of the state, and folks who are not in the county where there's a located can sometimes still benefit from those treatment courts. Chittenden County has a robust program, Washington County does, Rutland, and then there's a DUI docket down in Windsor. Deferred sentences are also a really good option at times. catered towards rehabilitation and other treatment-centered models. So just painting that picture about what's happening on the ground, we really do have a presumptive, oh, sorry, Senator.
Oh, no, I had a question, and it may be for you, it may be for legislative counsel. So yes, it's presumptive, but the court can appeal that and ask for a different sentence. And correct me if I'm wrong, it could also go the other direction. The court could say, actually, we don't think this should be probation, we think this should be diversion, or this should be a deferred sentence. It doesn't, I think I certainly initially made the assumption that it would be an instance of, no, we think they should go to jail, but it's occurring to me that my guess is the legal language says it could actually go in either direction. So it doesn't stop people who shouldn't get probation from getting probation. Correct.
Oh, yes. Yeah, so Ben Odrowski, so it would be incumbent on the state really to make a motion for the alternative sentence. A bit about whether or not it would be diversion or another sort of a community-based rehabilitative program. I mean, those aren't sentences per se.
Okay.
Sentences are once the case is adjudicated fully. So those other strategies could still be employed prior to sentencing.
And I think one of the things that when I was thinking about this is when I'm thinking about these factors and a presumption that has to do with a sentence, I'm thinking about that tail end of the case, not the entry point. The entry point, prosecutors with hundreds of cases are trying to make, the low-level cases, trying to kick them out of the system and get them some alternatives. Yeah, Senator Hutchins.
Quick question. So regarding additional motions and the additional hearings, and I'm also thinking about the court backlog that we've been hearing a lot about.
Yes.
What type of additional burden, or how large would this burden be for all the additional motions and the additional hearings that would need to get scheduled?
And I am going to talk about that a little bit more deeply. I know Judge Soni might be able to speak to that more eloquently on his side, but it would definitely add, I was trying to think about a way of saying it earlier, but maybe a series of speed bumps that together might create a longer time frame for the overall system of these low-level cases, which are for first-time folks. And so it will create another hearing. A lot of good defense attorneys might feel almost compelled that they should be filing these so that the state's attorney, if they're worried about a more harsh sentence down the road. Yes, Senator, sorry.
So I guess I'm just trying to understand, and it's been a really long time since I've spent any time in the state's attorney's office. I interned for TJ Donovan. He was a deputy state's attorney. I joke with him that the only thing he taught me was that I didn't want to be a lawyer.
It's a good teacher.
Anyways, so if I'm just trying to understand, so if we're the only time that this would create additional work would be if they were going to challenge the presumptive probation, right? So wouldn't this actually decrease the burden because most of the cases would just follow this course?
I think it's hard to determine because again, we're doing a little bit of a sentencing analysis right at the entry point to the case where sometimes it's the best opportunity to be the most flexible. And so I think it would create more hearings. I can, in a way that currently we're not seeing, because the way that it would work procedurally is someone might get their charge, come in for arraignment, and if it fits into these categories that the bill contemplates, the presumption kicks in, and then at that point the state might, when they know that what the charges could file an objection to overcome that presumption. So right there, for every single one of these cases, there could be an additional hearing. There could be. I'm not saying that they will, but there absolutely could.
But part of this effort, this bill, is to get to greater equity. I didn't say both geographically and racially. And I would think logically there'd be less cases, but I sense there may be not unanimity among state's attorneys on this. But anytime you take away something that they are the sole proprietor of, there's resistance. I know I feel the same way when they try to take issues away from the Senate Judiciary.
Honestly,
that's natural human nature.
That is definitely not the intention of what I'm trying to say. I truly do believe, me personally, having worked in this docket specifically as a deputy state's attorney, there might be certain cases where I want to go to diversion, but folks might think, well, at diversion, I'm going to have to admit something, and maybe I'll take my chances and just let this case continue. So there might be some folks that are now not opting to do diversion because you do have to engage in accountability at diversion, not opting to do CJC because, again, you do have to, whether it's a reparative board, you do have to engage with accountability. If you're extending that case and then this presumption kicks in, state's attorneys that we're offering diversion, we're offering CJC. And in my docket, someone in the 6 weeks or 8 weeks before, in between charge or in between citation and arraignment, if they've gone to treatment, if they've taken safe driver, they've done work in between, sometimes I'll dismiss the case at arraignment. And then it never, moves along. So certain individuals do not want to do diversion if they have to engage with accountability. They can think that they can take chances in the future. I think it's hard to know exactly how it will play out, but I'm not just saying it because it's taking something away. I don't see it as taking something away from state's attorneys at all. I see this as something, I'm trying to paint a picture of the current landscape of how this is playing out. And right now, this intended population, I'll get to why it's maybe overbroad, this intended population, low-level first-time folks, and again, what first time means is something that you think you have to determine. With drug offenses, those folks are often getting Tamarack or diversion, so they're getting something much better than probation, in my opinion, because they're not. When you put someone on probation, they are exposing themselves to incarceration. If a judge, the other side to this in terms of the hearing, beyond the initial one, is BOPs will be filed for folks that maybe aren't appropriate for probation, but wanted to say, oh, let's also be on probation. Let's say it's 6 months of probation with midpoint review, that's really 3 months. Let's say they had a test that is not in their favor in terms of substance use in that time frame. Give a BOP in a month. That is a court hearing with a probation officer where the state has to prove by a preponderance of evidence. And so do we want those folks to be exposed to incarceration? One of the questions, and again, I want to paint that picture without inserting an agenda.
Can I ask you then the same question that I asked Commissioner Demmel, if some of your reservation would be helped with an addition of some presumptive diversion aspects?
And so my opinion of diversion, it's already presumptive for individuals charged with qualifying crimes where we already have to state on the record if something doesn't serve the interest of justice. So there already is a presumption of diversion right now in our statute for the types of cases that I think are intended by this set here, and thinking about the intention as opposed to what is stated in the bill. The term nonviolent, as legislative counsel pointed out, does reference the listed offenses, and there are a series of offenses, including accessory and conspiracy to commit murder, that would be, not an enlisted offenses just because that's a technicality. Cruelty to a child, that's not your own child. Another one, plotting to blow up a building, burning down a house if someone escapes from that house and doesn't get killed, is a non-listed offense. So there's all sorts of offenses that are violent in nature that would be presumptively probationary under this. And I have a handout, which I'll pass along to you as well. Okay. But the listed offenses are often substituted as a sort of proxy for violent crime, but there's just well beyond that this bill would include as nonviolent, just because they're not listed in that. And the thing, as you said, it's cross-referenced all over our statutes and has become a bit messy. Conversation for a different day, I think, on listed offenses, but I just want to note that the definition of nonviolent in the bill is overbroad in terms of what we would see to be the low-level type of offenses that I think are the intention of some of the other statutes that we've seen across the country.
That's a point well taken.
And so in moving along to, I think, some of the more practical applications, in thinking about misdemeanors, nonviolent misdemeanors, assuming we can sort out what nonviolent means. On a practical level, a subset of these cases, I'll just give a few examples: disorderly conduct, petty larceny, possession of heroin, leading to an accident, negligent operating, operation. These are types of cases that we are making that analysis, and a lot of these folks, they might be getting probation already, but that would be maybe the most severe thing that they're getting. That set of community programming is what they might be offered before probation. Probation, and I've made offers in this landscape, might be something that is on the severe end. So it might say 2 days of work crew, pre-approved furlough for work crew, or 6 months of probation. Probation would be the more severe of those options. And so if there's a presumption of probation, I'm not saying it wouldn't necessarily help in terms of setting some of the bounds occasionally in some of these cases, but it would be more severe than what we're currently doing in misdemeanors. The real, and I talked with some deputies and our state's attorneys about the misdemeanor landscape, and they couldn't think of many contested sentencings where there was an argument over incarcerating someone or going on probation in that misdemeanor context, which is for me one of the most interesting. People think about misdemeanors as maybe not being that interesting. I think they're fascinating because it's a real opportunity to help someone the first time that they're engaging. And so those community referrals that you folks have empowered states attorneys to use are happening in my view for the low level first time offenses. Concerning felonies, and I just touched on it with non-listed, the embezzlement, right? It's a white collar crime, but it is technically non-listed. So embezzlement, if someone were to embezzle $100 million from the state of Vermont, they would have a presumption of probation. And as we know, like Bernie Madoff, the white collar crimes can be just as damaging to a community as a sort of so-called violent crime. There's also different, the concept of a first-time felony is just something to pause on and think about. First-time misdemeanor, possession case, simple assault. Simple assault's one where it's violent, but a lot of times that can be sorted out. I mean, really, the simple assaults that you might see come in the middle of the night can be resolved in a way that doesn't have to be a trial. So I just want to take stock that the application of felonies feels kind of more overbroad in terms of what this might sweep because of the reference to the listed offenses. Very rarely are judges doing written orders too, so they're often at sentencing hearings hearing arguments from both sides, and they're making that call about probation maybe at sentencing for the types of cases where it might apply. But the sort of motion practice that this might create another sort of step to is something that might slow off that process a little bit on the front end, making a case well outside its dispositional guideline. But the concerns on the backlog, I think you're thinking through them already, but I do think that we could be setting up folks beyond backlog concerns for failure. A first-time person is not necessarily someone that you want to be on probation, depending on that person's life. They maybe really would benefit from not having that be a presumption, because when I hear presumption, I think maybe that's a benefit. But for me, it might be setting up some folks for failure. If they're dealing with substance use, putting them on probation might be very difficult for them to engage with supervision, as opposed to a reparative board, which I know we've sort of talked about. Sometimes just talking to the community. Hey, I broke into the convenience store, and I had this case when I was working in Washington County. An individual came into town to collect a debt. That person was holding another individual at knife point. That created 3 other individuals to go try to rob 3 convenience stores and create sort of a ripple effect. Those 3 folks that did the convenience, they were feeling under duress to commit that sort of low-level type of crime. And for those folks, what they needed was treatment and attention to their specific case, which can be accomplished through multiple different things, including a referral at diversion, a referral at CJC. And I just wanted to say that I'm trying to paint the picture, not to say that this is a bad idea or a good idea, just to sort of talk about how it might play in the field. Yeah, Senator.
I hear that, and I appreciate that, and I appreciate that state's attorneys are given the authority to refer to diversion, and that is happening. We've seen numbers that that's happening, but I do have concern as to whether or not that's happening equitably. As I said before, we know that there is bias in sentencing. We know there is bias in all parts of the process. And so universalizing to me is a space where we can start to build that equity. And I wonder if in a subsequent hearing, we hear from the Office of Racial Equity or Director.
About this bill specifically.
Yeah, and whether or not the statistics that we have would back this bill up, or some version of this bill as being something that would build equity and decrease racial bias.
Yeah, and I don't have the
I
data
didn't
on that
expect
yet.
that you would, which is why I asked
Yeah.
for Director Davis.
Yeah, and I think one other thing, just practically speaking, and again, this comes down to what happens in the courtrooms every day, but just the ability for deputies to work with an individual case carefully. Having the offer, like I said, I might offer probation in a case, but I want to leave it up to that defense attorney and that person to think about whether or not they would be successful. And offering work proof, for example, is something some people say, hey, I would like to just do 2 days of work proof, because as I was talking about with both of the judges that I was recently practicing in front of, that sometimes the conviction itself is the penalty. With no probation, not a day served, just the conviction itself for first-time individuals can be the penalty itself. And I know it would be for me. I mean, having a misdemeanor on my record or a felony on my record sometimes is the penalty itself, and probation is on a more severe end. Not to mention, I know, and I won't speak to the Commissioner of Corrections, but just from my time in the field, staffing concerns about supervision. That's another point that staffing fluctuates, but putting more people on supervision can also.
Under the bill, the defendant could waive the presumption.
Right, and that could, with plea agreements, I think that would probably happen.
If we wanted to.
Yeah.
Anyway, are there other questions for Tim, or Tim, do you have any comments?
No, I'll happily pass out that chart just as the Big 12, which is, relates
Yeah,
to
no, I
juveniles and all that.
understand. There's confusion about what's violent, what's serious, what's not serious. Could you, Peggy, a suggestion was the next time we take up this bill, we hear from Zana.
Oh, I already added it to the list. I'll say.
You already did it?
Yep.
You're good.
I heard. Thank you.
Judge Zone,
Thank you all very much. Thank you. If not, I'll be here for questions.
welcome.
Morning. And for the record, Tom Zone, Chief Superior Judge. I would agree when Mr. Leaders Dumont says that Vermont, we have individualized sentencing, and that is really what is set forth. If you look at Title 13, Section 7030, and that's the statute that talks about sentencing alternatives. And I lead off with that because my first comment when I read this bill is that I think it should not be in Title 28, but it should actually be added to 7030, because that's where the factors and the considerations for sentencing are included. The section of Title 28 is more of a section that is for implementation once the decision has been made to impose probation. And so I think when you look at Section 7030, it comes right out and says, in determining which of the following, and the following are the sentencing alternatives, should be ordered, and it has the factors that the court has to consider, which are individualized factors. And so I think structurally, any change really should be in that section, because again, that's where the factors are when we decide in court what the sentence will be. The question that arises when I am thinking about this is, and it was mentioned before, is how much of an impact would this be? And the answer is, it depends. Because as our statistics showed last week, 99.68% of the cases were involved with plea agreements. And it would seemingly be that most of those cases were not contested sentencings, but rather were cases that may have had binding plea agreements. And so I would suggest that where it talks about language that this could be waived, that the entry of a plea agreement to a binding sentence is a waiver, or a sentence that includes something other than probation is really in effect a waiver, to make it clear that if the parties agree to it, that waiver goes forward. And we don't have a significant amount of contested sentencings. I can't, and maybe Mr. Valerio has a different read on this, but I don't see that huge number of contested sentencings that would necessarily fit within this category. Most of the cases, again, come before the court on plea agreement, or if we have a trial. And that leads me to a concern I have, and that is this entire process is started by the state. Where's the court? The state may think it's going to go with presumptive probation. The defendant may be happy because the state hasn't filed that notice. And yet the court at the time of sentencing hears all the evidence and hears from victims and concludes that after consideration of all the sentencing factors and alternatives, that something other than probation is appropriate. Maybe a day of work crew, because this would not allow work crew. Maybe a fine. A fine is different than presumptive probation. And so that's a different component of a sentence. And so what this does is it takes the ability of the court to exercise its discretion in cases that it always has had discretion as far as considering all the factors and determining the appropriate sentence. Because what does the judge do after a trial and the state doesn't file something? Does the judge after the sentencing hearing say, okay, stop, now we need to go and create a process that doesn't exist to say that we're not going to give presumptive probation? And so I think that's troublesome. And as far as judges getting involved early on in the process, in the alternative of the state making the filing, judges need to wait until they get all the evidence before they decide what the sentence should be. And so a judge shouldn't really be weighing in and saying, well, I'm not going to give presumptive probation here, I'm going to give a different sentence, until they've heard from everyone at the time of the sentencing hearing. And again, sentencing requires a number of factors, which includes deterrence, punishment, rehabilitation. And so it includes the statutory protections for victims. And this bill kind of creates a bifurcated process where we're going to have a hearing up front. It doesn't say the victims necessarily have to be there. That's not one of the criteria that we're supposed to consider. As far as the victim's views, certain aspects of the victim's impact would be considered. And so when I look at this, what it really appears to me is that this bill could be put into section 7030 as a consideration at the time of sentencing by the judge. And the bill could be structured in such a way as to say that there is presumptive probation, and if the court does not impose the presumptive probation, the court shall set forth its reasons on the record. Because that is really what this entire process is geared towards. Why isn't this occurring? And a judge would have to back that up. And the defendant, if they felt that a judge did not have an adequate sentencing decision, has the right to appeal that. The bill provides for written orders. Most sentencing decisions are not written orders. Occasionally, judges will do them, but the majority of sentences are imposed on the record. Judges will listen to the evidence, get off the bench, collect their thoughts after hearing from the parties, and then come back and deliver a sentence. Adding a written order requirement could potentially delay the imposition of sentence, remove that finality that is important for people to get at that time, and cause issues that don't need to be there. Because if a judge comes out and just reads a sentence off their notes and then goes back and writes something, well, sometimes they might not get everything they said right exact and the same. And then that gives rise, well, what did the judge mean? Did he mean what he or she said on the bench, or did they mean what they wrote? And again, sometimes judges will write a sentencing order, but that's generally not the way it's done, especially when we're looking at the backlogs. And I can't say that this bill will add a significant number of a significant backlog impediment, because realistically, we're not having the contested hearings in these cases now, I don't think, at a huge level. But it will, I think, add potential for it, because you might get the state filing that notice or filing something when otherwise it would have worked itself out before the sentencing hearing. And so we're going to be having repeated hearings. You're going to have the hearing on whether the state's filed the motion, and then you have a sentencing hearing after that. And then the statute provides that that a party can appeal from the decision at that initial hearing. Well, does that mean it's what's called an interlocutory appeal? Does that mean they get to appeal that decision before the final sentencing decision? And so the short of it is, presumptive probation is a legislative determination and a legislative policy. If the legislature decides to go in that direction, I would suggest again that it go under section 7030 as something to be decided at the time of sentencing, as opposed to separate proceedings for it.
Appreciate that, Judge. Senator Wolf, he has a question.
Thank you. Thank you for your testimony, Judge Zone. I'm wondering what training and or support is required by the judiciary to help judges consider their own bias in sentencing.
Every judge who's appointed to the bench in Vermont will attend the National Judicial College General Jurisdiction Program. There's a specific program there that is sessions there that are administered generally by Kimberly Papillon, a national expert on neuroscience and the science of decision-making, which focuses on implicit bias and decision-making. Since 2019, each year at Judicial College, we have had programs addressing implicit bias for judges. We have had programs also for training in Vermont for judges on procedural fairness, which talks about which includes concepts of implicit bias, awareness of such matters.
You said this went into effect in 2019?
No, I'm just giving you off the top of my head. I know that in 2019, we had training 2020, 2021, 2022, and we're having Judicial College in June of 2023, and I can tell you that there is a section on implicit bias that is being offered at that time that will be required for all judges to attend.
Awesome, thank you.
Other questions for Judge Zone? Judge, thank you.
Thank you.
I think it's wise not to travel to Bennington tonight for you.
Well, thank you. I'll take your advice on that, I think.
I will, you can blame me.
I appreciate it.
From Senator Sears?
Well, I watched Albany weather this morning, right? Doesn't look good. We hope Matt makes it back to Rutland.
I'm mindful of the St. Valentine's Day blizzard. Remember that? I actually drove here in that.
One of the few.
I didn't get out, but I got here. When I came out, my SUV was literally covered with so much snow I couldn't even see it. Yeah, well, I don't think I'd do that now, but I was young and dumb.
I think that was the night that Senator Westman and Senator Hartwell lost their cars.
That's right. I remember.
Seriously,
that.
I mean, I think eventually they got towed, but.
Yeah, I couldn't move my car, so I walked from my office only to, Capitol Plaza to get a room. And I said, it's not far. The snow was up to here. I felt like I run 3 marathons by the time I got there. Couldn't breathe, totally drenched in sweat. I don't
think it's going to be that bad tonight.
No, it won't. But that was too on my part. And so again, I met with Defender General, and I was interested in what everybody else had to say about this because I wondered if my thoughts about this bill were kind of off the wall. And I will tell you directly that I do not support the bill. I don't support it as written. I conceptually, I think it's trying to reach at a problem that doesn't exist here. There are a couple of things I think we have to remember from Justice Reinvestment 2. The feeders of the incarcerated population that we're trying to get at were 3 major areas: probation violations, furlough violations, parole violations. Those were the biggest feeders of the system for incarceration and reincarceration. Part of it was people staying on probation too long. Some of it were just the administration of how people were getting off of probation. One of the things I can tell you definitively is that focusing on probation in the misdemeanor system is really the absolute wrong place to look, because for the most part, people are not getting probation for the types of crimes that are focused on in S15. So my fear is that you are actually you may end up getting more uniformity if you kind of get at that issue of racial and imbalanced sentencing. But you're going to put more, but to get uniformity, you're going to put more people on probation and subject them potentially to incarceration consequences down the road, when without this bill, they wouldn't even be on probation. When your presumption is something that leads to higher consequences, yes, you make everybody the same, but you also end up putting people in jeopardy that wouldn't otherwise even be in jeopardy. I think that I have issues with the the procedures that are in place in the bill as it's written. But looking at the overarching issue, you're getting at the wrong group. If you were going to look at a group, to me, that would benefit from some sort of presumption, what you really should be looking at is low-end felonies, non-violent felonies, first-time misdemeanors that may have a component of violence to them, but the person has never had a record before. So you might be looking at simple assaults. You might be looking at mutual affrays. You might be looking at disorderly conduct, aggravated disorderly conduct. But the difference between a misdemeanor, unlawful mischief and a felony unlawful mischief is the size of the plate glass window that you put the brick through. If you happen to throw it and you hit the one that's
That one?
smaller, that might be a $20 piece of glass. You hit the bigger window, and now it's $1,000, and you're in felony land. But the intent and what is going on from a criminal standpoint is no different at all. So this is the kind of thing, to me, where a focus on nonviolent felonies and misdemeanors that might actually contain an element of violence. And yes, that might mean domestic assaults. It might mean simple assaults, because there are domestic assaults and then there are domestic assaults. They're not all the same. That's the kind of thing where you look at it as a judge or a prosecutor and say, no, we want the presumptive probation for this person. And the defense is going to make an argument that we don't need that, or the prosecution says, well, we have presumptive probation, but this person should do some jail time. And now you get an argument about whether jail time in a domestic or in a simple assault is the appropriate thing to do. Because some of you may know, you can commit a simple assault without ever having physical contact with somebody. You can commit a domestic assault without having physical contact with somebody. There are also violation of abuse prevention order cases where you've got the sort of the ones where you have contact and arguments and threats and that kind of thing. And then you have the ones where you have to come within 50 feet of the person you weren't supposed to be in contact with. And you end up racking up these charges along with violations of conditions of release if there's a pending case. And the person may have had no record beforehand, doesn't understand how the system works, and that person is not appropriate for jail time, although some particular prosecutor might think so. And presumptive probation, it might be the right place to start. If you can have an argument about it, those are the cases that you should have an argument about, not the retail thefts and the very low end misdemeanors that aren't getting probation to begin with. So I worry that this is actually going to feed our system with potential incarceration. Not in the first instance, but by having people on probation where they're now, as we say, in the system. If you remember a few years ago when the legislature adopted this, for many misdemeanors, there's a requirement of administrative probation that you do not, but yeah, you're on probation, but basically don't do anything wrong. You complete your term and you're done. We have already addressed, I think, this population of people who this bill seeks to address. The issue of racial inequity and what is going on in sentencing, I don't think necessarily is helped by this. In fact, it may exacerbate it, but on the probation violation end, not on the actual sentencing end. And while your sentences may all look the same, it doesn't mean they're appropriate. It just means they're the same. And so I don't like this bill. And I don't like it as written. I don't like the way it is structured.
It's not Ben's fault.
Well, it's not, that's nobody's fault. I mean,
Just made it clear.
what I think.
Well, when you say I don't like the bill, I didn't want Ben to take it personally.
Well, what this bill, I think, is doing is looking at problems in other jurisdictions where serving a few days on a misdemeanor is not unusual. It's like this is a national kind of bill that isn't something that we really see from a sentencing standpoint in Vermont. I'm not saying there's not bias in the system, because there clearly is, but the people who are involved at this level of criminal activity are not getting that.
I think I've got your point.
I mean, I can talk about the various, as written, some of the issues with like the appeal process and the structure, but that assumes that the concept
Be
is
your
right.
testimony that you'd rather we not go forward with this bill.
Yeah, at all.
What about presumptive diversion?
Presumptive diversion takes it out of the system completely. And so one of the things I was going to say is all you, the senator, you had talked about, diversion. All of those things are things that can happen already outside of, and when you have presumptions like this, the presumption is against anything but what the presumption is. Now you've got to work into things like deferred sentences, community justice center referrals, diversion and the like. If there was I don't think it's a bad thing to have, and we do already have a diversion referral presumption for certain crimes. I don't think what is contemplated by this bill is easy to plug in, but that concept does definitely keep people out of probation, which keeps them out of legal jeopardy down the road. I've often said, and we see this just statistically, and I don't know if it's changed some, the people who get into the system, the criminal justice system, 80% of them we don't see again. 20% come back, and they keep coming back, and they keep coming back until they're like early 40s, right? I've often thought, and I've said this before, is the less we have government involved in low-end stuff, the more likely those people are not going to be back in our system. You don't want to see violations for activity that is not otherwise criminal, but might still be a violation of your probation. That's one of the things we really try to get away from, and that's why we have the administrative probation statute that was passed a couple of years ago. I also am concerned in this bill of the ability to extend the term of probation based upon a failure to complete. I would admit some of them, in some cases, it might be treatment and the like. One of the things I'm worried about right now with that is I don't know that there's enough ability to get people in and out of treatment in a, all counties particularly, in a meaningful way. You're gonna have some where the counties have more treatment resources and ability to rehabilitate, get them into programs, do whatever they have to do. Other counties where those programs don't even exist. The best thing I think we can do for low-end offenders is to not over casework them, not over supervise them, not over treat them. As long as you get somebody on, if they're on probation for a year or two, they haven't violated their probation, they haven't committed any new crimes, the term of that probation should be the end of their involvement with government, and we should move on. If they present themselves back, with another crime, well, now it's a second offense, and we're going to deal with that different or more, and we're going to deal with that differently. So I was actually, I know they took the softer approach, but I'm hearing the same theme from other folks for different reasons.
Yes, I am. Thank you. So I think Peggy will just hold off on this bill for a week or two and see if there's some ideas on the presumptive diversion.
And Mr. Chair,
If
if
you
I may on
can
that.
send any information to Ben, that might work for that. And
Can I just ask a quick question? So I heard you talking about this bill sort of addressing the wrong crimes. So I'm trying to understand, do you support this idea for different crimes, or do you not support this idea at all?
I think that if you were focusing on a higher level of offender, which might mean lower end felonies, misdemeanors that have an element of violence, then you're looking at, so if the prosecutors in a domestic case, for example, don't like the presumption of probation in the domestic case, then this process with tweaks to make it not so cumbersome and fit with the rest of like our law conceptually works. I think you're looking at too low a list of offenses. You've got to move up a notch. Low-end felonies, misdemeanors that have elements of violence, that sort of thing. The embezzlements, the bad checks, the false pretenses, all of these felonies. We always think about, well, drug cases and shoplifting. Well, there's all these other things that are out there routinely, especially these false. I mean, I'm sure that you saw in your prior career that these quote unquote embezzlements from people who are working at convenience stores and passing bad checks, and like this is a big part of this, but they're felonies because of the dollar amount, but the criminal thinking that goes along with it is no different than the low end offense that happens to be a misdemeanor. So I think that's where you've got to look at, because those people do have a threat potentially of going to jail because they're felonies, and they are the kind of case that may be a presumption of probation is the appropriate place to start, as opposed to the potential even of a small amount of incarceration. There was a study that was done by John Perry and Bill Young some number of years ago, and it was right after John Perry retired from the Department of Corrections as a statistician. Basically, what the study said is that for nonviolent offenders, any incarceration led to a much higher recidivism rate, and I'm talking about days, 1 day, 2 days, 3 days, compared to people who were on probation, received treatment, and were not incarcerated. Incarceration is a bad thing when it comes to recidivism. So the people who need to be incarcerated are people who, in my view, are those that need to be isolated because they present a danger to the public. that focus, is generally what we are trying to do with the Department of Corrections and have been. What we don't want to have is low-end offenders get caught up in a probation cycle where they end up incarcerated, notwithstanding the fact that they don't present violence, even if they can't keep themselves, on the straight and narrow in general.
Thank you for.
People
making
have
that
different
clarification.
theories on this, of course.
I understand, and I totally understand. This bill was part of Justice for Investment. We introduced it,
Yeah.
we heard your opinions and take
I
them
think if we were
seriously.
Pennsylvania, this would be a perfect bill.
Or Georgia.
Yeah, there's a lot of places around where, doing jail time for misdemeanors is common.
Yeah.
Doesn't really happen here.
Okay.
Commissioner Double, do you have any statistics for your population on if there are any folks serving jail time currently for misdemeanors?
Sure.
Thank you.
Yeah, we'd be happy to send that along.
So, whatever we did for this bill next week, we just cancel.
Okay, so that was, pretty much,
I mean, it sounds like there's still work to be done. I guess you just did not work.
Thursday.
Pardon?
It was from 9 to 10:30 on Thursday.
Well, to be determined. Probably could use some time last for, I'm sure we'll.
Well, yeah. So I'm gonna stop the live stream now.